Hi there. We're here again for another video, and as always, I have my notes up. This video is going to be primarily based about pro se child custody hearings, and if you are in this video and you have already opened a case for child custody, this video is not for you. If you are starting from scratch, looking at filing for child custody, haven't filed yet, there is no open case by you or your partner, co-parent, counter-parent, whatever you want to call them, this video is more for you. So pro se, in court, it just means that yourself or the other party is involved, self-represented. Many people don't hire attorneys. I didn't have an attorney for a few of the things that I had done, like a restraining order, and a couple other things. So as I said in previous videos, my case is constantly ongoing just because I do co-parent with somebody who is, there's founded child abuse involved. So all of my things are all of the personal experiences that I list are things that are factual based. So if anything is still up to perception, I don't really mention it. That's kind of why I sound maybe a little bit aloof. So yeah, like I said, this specific video is to help people start the filing process and or the court processes. If you've already established an open case, please go back and find maybe how to win a video. I know Judge Anthony on YouTube does a ton of really great videos about that, especially battling narcissists. And one of his classes will be linked in the description below. It's a sort of a crash course that is 100% free on how to handle a narcissist in a courtroom. He is a prior judge. He's a current attorney and a family law lawyer. So these are all the things that when he went through his own divorce, from what I understand, he sort of decided to kind of buck the system, so to speak, and give a bunch of legal advice, certified, because he's an attorney, for free. So if you haven't seen his videos, please jump over to his channel, Judge Anthony. You can search it, find his stuff anywhere. I'll cite some of his information below for you to click on as well. So before any hearings take place, I know it sounds scary when you go to court. You're just like, oh, we're going to be in front of a judge right away. Not the case. It's many steps just to get in front of a judge. They don't want their time wasted. So if it took 30 seconds to get in front of a judge, I can't imagine how many judges would have their time wasted on a daily basis. You'll need to either ask for or find a complete petition/motion packet. And the reason that I mention many names is because I'm hopefully going to try to open this specific video up to any state as best I can. I only have two separate states of experience, Oregon and Colorado. So Oregon is a 50-50 state. Colorado is not a 50-50 state. They're primarily mothers getting custody. So those are the two perspectives that I can give you. If you are a dad filing for things, definitely do a lot more research, just because there are some stigmas with dads claiming things like abuse and stuff like that. There's a lot more stigma. You're fighting a lot more of an uphill battle at that point. So yeah, do your research. So the petition/motion packet. A motion, if we start from square one, is literally just you raising your hand saying, this is what I want. That's your motioning, right? That hand raising, you're motioning for your needs and wants and desires and whatever else may be in the best interests of the children involved. In most places, this packet is pretty lengthy, so I always suggest some headphones and a quiet space when you get it done. The first time filling it out, it's going to be a lot. I remember when I filed for custody and I had to fill that packet out probably like 3 or 4 separate times because it was a lot. You're going through a divorce too, so you're emotional. We're not thinking with our cognitive brain, which makes language really difficult to pick up on. You couple that with learning legal jargon and it is really hard. So that packet usually has everything you need in order to get your motions started, in order to get your court case opened. Usually has everything you need inside of it. The one that will take probably the longest for you, or should take probably the longest for you, is the parenting plan. So typically you'll have just one sheet of paper in the packet that says parenting plan that pertains to Exhibit A, for example. It should be the first exhibit because one of the first questions in that packet is going to be who should have sole custody of the child, or 50-50 if you guys are coming to an agreement. That's also fine. A lot of couples enter pro se because they're co-parenting, which is the best outcome that we can wish for any kids. And the kids are going through a divorce too, so it's especially important to mention that divorce or custody hearing, whatever, changes in general. So Exhibit A, or parenting plan, it's usually one of the first few things requested, following, like I said, the earlier section, which will ask you who should have primary custody of the child or children involved. Parenting plan Exhibit A will be the parenting time that you suggest for the non-custodial parent, should you be pursuing 100% full custody. Custody comes in two separate forms. It comes in legal custody, physical custody and legal custody. Physical custody means whoever the child will be living with greater than a certain percentage of time, and that percentage changes from state to state. I think in Oregon it was like 75% of the time or more that parent should be granted full custody, really without question, because that's where the kid is living. Then there's things like medical or legal custody. So medical custody is different. A lot of states will rule that 50-50 because they want both parents' input on the medical care of the child or children. If you are dealing with an abuser, okay, this is a lot of information, so make sure you have a pen if you don't already. If you're dealing with an abuser, I strongly recommend that you shoot for 100 and 100. And the reason behind that is because if you have full custody and full medical decision making, it doesn't give them a lot of leeway. If you decide to be empathetic or leveling with them rather than actually caring about the child's best interests, which if your case is an abuse case, is not 100% 50-50 with the other parent. That abuser will find ways to use it to manipulate you for more control, coercion, fear-mongering, things like that. So I strongly recommend 100% of physical custody and 100% of medical decision-making. It's just like a job interview. If you shoot for the highest number, they'll meet you somewhere probably higher than what you had originally requested if you were just going to scrap it and go with 50-50. Obviously, if both parents are getting along, there's no abuse around, and maybe they are narcissistic, but they are, they have some insight. They understand what they're doing, what they're going through. You can always go back into court and change this. And then if you are requesting child support, that's also another monster. You'll need to include financial documentation. With my case, and this is just something I can speak to, with my case, I chose to go without because I knew it was going to be one extra thing that was going to have to force me to communicate with my abuser, and sort of give them another option for power and control over my lifestyle, or, things that I wanted to do with the kids or something like that. I did not want any more of that. I was done. I was over the abuse. So I opted for no financial support. That's been working out pretty well for me. I hear nightmares about parents who do get child support, and it's a pain to track down. Odds of getting paid from an abuser who likely can't hold down a job is slim to none. Odds of the state catching up with them, slim to none. I think at best you're looking at maybe a couple years of tax returns for back pay. After that, they'll find new and interesting ways to keep their money away from supporting their children, which, whatever. That's not my ball game to live with. I don't have to deal with that inner argument. So in some states also, and this kind of, the way that I'm organizing this is it's going through the packet as best I can. So I pulled up a packet that I use from Oregon and a packet that I use from Colorado. Both were very, very similar. So the next packet-ish, depending on the state, once again, will be a co-parenting class requirement. Most parties, if you're filing for custody orders, original custody orders, you'll have to attend a parenting class. If you are on Medicaid or state assistance of some sort, those classes are going to be free. You just have to network and talk to the court clerk, talk to like your local offices, domestic violence shelters. They can hook you up with all those benefits for free if you are already on state benefits. If you're not on state benefits, I do know there's options, but you have to explore them. I forgot to mention, I will also link a co-parenting class below. You just have to click that link, sign up. It says on the website that it's recognized by all 50 states. I have yet to see a program that's actually recognized by all the counties in the state. So the terminology there, we're recognized in 50 states, but it might not be your county. So go to the court clerk, check with them, figure out if they have specific sources that they want you to use. It's always best to use what the judge recommends because it's going to give you the least amount of hard time in the long run. So it might be a more expensive program. Scrap together the cash if you got it. Just get it done. It's a check in the box. Just get it done. If you have evidence of abuse, police reports, DHS reports, photos, emails, texts, anything that was recorded, video calls that were recorded where the person was verbally abusive, that's all recognizable for the most part in court. Sometimes people can get around text messages pretty easily by saying, oh, it's somebody else or whatever. There's a lot of loopholes. So definitely make sure that if you are stacking your case and you're building an argument, that you do it with multiple different formats, because just having text messages is not going to be substantial enough for a judge to be 100% confident. We have to remember that a normal brain, a normal psychiatric makeup is not going to be very accepting of the possibility that you went through all these dark, horrible things, because they're not normal things that you went through. So the normal brain is going to have a hard time grasping the depth of what you dealt with or what the kids dealt with. So if you have any evidence, the other thing is the earlier you can get your evidence filed, and this is just a psych tip, the earlier you get these things filed, they serve two purposes. The first purpose includes getting those things properly filed so your motion isn't denied. If you file something about abuse in your motion and you have no evidence included, the judge is going to throw it out immediately and you're going to have to start from scratch. So, as you go, make sure you're checking in with the court clerks to make sure you're doing everything appropriately and nothing gets delivered to the judge late. That being said, when you file these evidentiary, items, you're going to have to file them with an evidence submission form of some kind. They all have different names. Those typically are not included because domestic violence is abnormal. We have to remember, it might be normal for us because we've been living in it for years, multiple years, 1 year, 6 months, however long. So we have to ask for those forms. Get those with the court clerk. The earlier you submit those things, the more time a judge has to get to know your case. And if it's interesting, if it's intriguing, they will remember it. They are people. People forget when we go through the family court system that judges are human beings, and they forget things. They forget normal things, day-to-day things. But what they don't forget are oddball things that were submitted with your case. Clerks and judges speak one-on-one about different filings. If there's a question about a filing, the judge will call the clerk and talk to them. So the more FaceTime you get with these clerks, the more the clerk is going to be able to sort of advocate for you, because they're going to say, oh, well, she came in here the other day, filed a bunch of things, didn't know how to file them. I helped her. She's pro se. She's came here on her lunch break, little things like that. It pays to mention that stuff. Oh, I'm swinging by on my lunch break. I don't have any time. Can you please help me on how to file this? I don't understand how to file this. They're people. They're going to want to help you. You just have to ask for it, and you have to help them understand the overall picture. Clerks and judges talk. They communicate verbally. They communicate via email. I don't know if it's over text so much, but from the clerks that I got to know in my proceedings, they communicate and they talk to the judge one-on-one, and they explain. Essentially, they give a basic picture of who you are to the judge when you're working hard, when you are a common face and you're in front of them, bothering them, bugging them, getting this information, sitting in the lobby right in front of them and filling it out, doing it all the legwork, doing it. They're going to see that that's not normal. Most people will take the paperwork home and file it incorrectly and then have to come back, and they'll do the same thing over and over again. But if you're sitting right there in front of that clerk, filling it all out, asking for help, taking up, an hour, 2 hours out of their workday, their 8-hour workday, they're going to remember you and they're going to talk to the judge about you. That's just the truth. People, and once again, this is not legal advice. I'll put the disclaimer below. Blah. So, yeah, they can explain the subjective information and, like I said, sort of psychologically paint a picture of the case prior to the judge meeting you. If you have shared property together, that's going to be another form to fill out. In most states, if you've been married for longer than 3 years, that makes all of your debt and property joined automatically. So you'll need to include those things like the housing, the cars, the debt, credit cards. If you don't have access to any of that, that's important to note. The judge is going to want to ask the other party why you haven't been involved in any of that, and they're going to have to explain themselves, especially if you're both pro se. The judge will not be a fan of you being unprepared, and I'm assuming if you're filing custody, you likely have the children in your care as we speak, so why the other co-parent would not be allowing of that doesn't make sense to anybody. Keep in mind that abusers will often try to take anything that brings you happiness. So if you have an attorney and you've been, married for less than 3 years, do not budge on anything financial. If you have an attorney, you shouldn't be here in general, so I don't know why I noted that. But, do not budge. If you've been married for less than 3 years, they can request whatever they want. But if your name's on it, do not give it to them. They will do everything in their power to hold that over you. I remember in my situation, I opted to give back my wedding ring, and when I mailed it back, that was taken advantage of, and I was told a lot of horrible, awful things about how I didn't hand deliver the ring, even though I lived, 3 or 4 states away at that point. So he had entirely expected that I would show up and try to hand deliver this ring, thus giving him another option for some more abuse. And in reality, I just mailed that thing back with FedEx. I was not dealing with it. So also wedding rings, you don't have to return those. Engagement rings you do legally, but wedding rings you don't. So don't worry about it. Once the packet's finished, you'll also have a proof of service document. When they give you the packet, the proof of service is usually in the back. And that's because it's the last thing that you sign. So that document, the paper will be, when you're done, when you're done, the paper will be stacked on top. Copy the whole packet. Copy the whole packet. I don't care what anybody says. Moving forward, you are in a business transaction. You need copies of everything. So birth certificates, passports, ID cards, insurance, you name it, get those copies. So before moving on to any other step, make sure you take the entire packet to the courthouse again, have the clerk look at it, make sure it's 100% filled out, 100% accurate to the best of your ability, and don't forget to ask the clerk about getting anything notarized. This is a frequent thing that I see a lot of people miss. You have to get the packets notarized if they require it. It's going to cost you money, anywhere from $5 to $20, but you can Google, notary of the public, wherever you have it locally. Post offices usually do it. Sometimes, mortgage offices will have a notary that can do it for you. They usually will be a big fan. Make sure they don't upcharge you $5 to $20. So once your packet has been okayed by the court clerk, then you're going to take it to the police station. This is once again pro se. Take it to the police station or the sheriff's office. It depends on the address that they're at, where they have to get served. My listed home address when I was in Oregon was in the county. So all of my dealings went through the sheriff's office. If you're in the city jurisdiction, inner city, that's going to be the police office. So they have their own proof of service usually that they file with the courthouse. In those situations, you don't have to do a thing. You hand them the packet, they'll file the proof of service, you're on about your way, no harm, no foul. Sometimes you should be asking anyways, especially if it's your first time, because the service process, that's going to become your best friend over time. So Double check with the police officer or the sheriff's deputy at the desk, at the front desk that you spoke with. Double check as far as what your next step should be. Sometimes they'll mail you a proof of service that you have to then bring back to the court with everything that they mail back to you with. So you might have to bring that in the courthouse. You need to ask. There will be a fee for that. It depends. I remember a couple years ago it was like $35, and then this year I filed some other things and it went up to $50. So it just depends. If you don't have the money, girl, you got to figure it out, or guy, you got to figure it out. You got to get it there. It's one of those checks in the boxes that you need. Ask them how much it costs ahead of time, just in case you need to scrape the money together. And generally there's a time limit on how long you have to get them served. So I know in Oregon it's 30 days. In Colorado it's 42 days. So you got some time. The next step that you have, it's going to vary state to state. So you'll need to explore the online options if you haven't already. The reason I suggest this, exploring your options for as far as virtual court hearings go, is because in-person court hearings, especially when you're pro se, they can result in what's called a cross-examination. So the other party being allowed to ask you legal questions in a courtroom. And, I hate to say this sort of with a touch of humor, but we all remember what it was like living with these people, and they're drilling you with questions, and there's jealousy, there's confrontation, there's anger and hatred and loathing and whatever else, whatever other emotions there may be. It's not easy to sit in a courtroom in front of a bunch of strangers and continue the abuse, really the manipulation that they are capable of in a courtroom. So explore the virtual options, keep it safe. It's better to just be safe. Evidentiary hearings usually are what's next, and that's when both parties present the evidence that they've already submitted. So you can't bring new evidence to this. This is why I'm telling you, the sooner the better with your evidence. And not to mention, when you submit your stuff first, that's who the judge sees first. So keep in mind, you can submit evidence at just about any time during the business hours, obviously, in a courthouse. They'll give you that evidence submission form. Like I said, verify the name of it. Just tell them you need to submit some evidence for your court case, and they'll give you everything you need. Please keep in mind that everything is different in various states and counties. The best thing I did through my whole process was to make a lot of contact with court clerks, and I checked my work every step of the way. Make sure to do that, communicate with them, and help them paint that picture. So I hope this helps. I hope this gave you a good starting place. Go back and watch it again. Make sure you have all the steps written down, and then go to the courthouse, pick up your documents, print them off from online. A lot of times you can find online self-help forums. They will, online on the courthouse website, you'll find the self-help forms and be able to pull up, dissolution with child custody motion, something to that effect. It won't be what's called an order. It'll be, because we think child custody order. No, an order is something the judge does. Motion, you do a motion, or you do a response to a motion. Hopefully you're ahead of the ball game. Stop by Judge Anthony's channel on my last note. Make sure you get some of his resources, co-parenting, counter-parenting with a narcissist. You got this.